A child support case between a supermodel and a French billionaire made news headlines. The model had been seeking $46,000 in monthly child support payments. What would happen if that were to happen in Texas? Live at 5's family attorney Sonia Kaufman joins us now with details. And I know most people are thinking $46,000 a month. That's a lot of money.
A lot of money.
But is that reasonable?
If that had been granted, that would have been the record child support award, I believe, in history. But in Texas, most people fall under guideline support that we're all familiar with. It's the percentage that's applied to the first $7,500 in net resources. But occasionally, there are situations with really high earners that the parent on the other side thinks that they need more than guideline support. And that is sometimes granted if that parent can prove that the child has needs.
Such as what?
Well, needs in excess of what the child support would be. Things like that people argue over would be private schools. There has been a case of a bodyguard granted for a child.
In Southeast Texas?
Well, no, not in Southeast Texas.
But in Texas in general?
In Texas. This was in a border town where there was some danger, and the court did think the bodyguard was warranted. Things like expensive summer camps. There's even a case in Texas where the court found that the child's clothes from Neiman Marcus was a proven need. So it depends on the earnings and the circumstances of the situation.
And this obviously, her being a supermodel and dad being a billionaire, I mean, there were a lot of things. And of course, it's an undisclosed settlement?
It was. But what I heard her saying was that my child should have a comparable lifestyle to the billionaire's other children, and that is not a basis for child support in excess of the guidelines. It's not to support lifestyle, it's to meet unproven needs of the child, or unmet needs of the child, I should say.
All right, let's get to some of our Facebook questions. At what age will a judge let a child choose which parents to live with? I think we have this pretty much every time you're on.
People always want to know that. At 12 years old, the court is required to listen to the child, but the child never gets to decide. The court always has the final word on what's in the child's best interest. And it is a very stressful thing to put a child in the middle. Most people are gung-ho. I want the judge to talk to my child. Most children don't want to choose and don't want to be placed in that position, but people bring them to the courthouse every day.
All right, may want to think about that. My daughter is 17 and court gave custody to the father. What legal age will she be allowed to come home?
Well, the possession and access order goes through the time the child is 18. As a practical matter, I think most judges would say that you can't force a 17-year-old to do a whole lot. As a practical matter, 17-year-olds are usually driving and going back and forth at will. So.
All right. Now, unfortunately, we've got lots of other questions and not enough time, but we'll get to those the next time you're on. We appreciate you stopping by.
Thank you.